Greetings. Welcome to ITR Live. I'm your host, Chris Hagenow, and welcome back to another action-packed, fun-filled episode of Iowa's favorite conservative podcast. We are honored here today, Chris Ingstad and myself, with our first ever three-time, three-peat, Triple Crown guest today. We've got Alan Ostergren from the Kirkwood Institute. Welcome.
It's great to be here, guys.
Is it really?
It is.
Okay,
It
good.
is. That's legit. That's not just radio personality coming through. I am legitimately excited to be here and spend some time with you and your large audience.
Well, that's what I wanted to ask you about, Alan. Chris may have other things he wanted to ask you about, but I wanted to ask you, of all the things on your resume, right? Former elected official, you've been a prosecutor at a number of levels, you're an attorney in private practice, you founded and lead a public interest law firm, you were a contributing scholar to the ITR Foundation.
Yes.
Do all of those things pale in comparison to being the first three-time, guest Triple Crown winner of the ITR Live podcast?
I thought the greatest accomplishment in my life up until this moment was being on a state championship chess team. But that has been surpassed by being a three-peat on the pod.
Well, it not just a three-peat, but the first one.
Yeah.
Yeah.
I mean, I think it's kind of like Saturday Night Live, the Five Club or whatever they call it, the Fiver Club, where you get the jacket. I feel like there should have been some merch when I got here.
Yeah, we could do that.
Like a coffee mug
that's actually we could do that. That's a really good idea. Yeah, we're definitely on that.
All right, Hagenow.
Okay, gear.
Hit the internet button and get that ordered up.
All right, good. No, that's fantastic. We need to talk chess sometime. I didn't know that you were. I'm terrible, but I enjoy it. So I wasn't on any like top flight chess teams, but
I was good. And then I had a ACL tear, and I just couldn't come back from it.
Knee injury.
Lost your whole senior season.
Back then, the rehab wasn't what it is like now. They didn't have the cold therapy and everything.
Tommy John surgery for
right. And I just let it get to me, and and they sent me down for a rehab assignment. I just never came back up. High school chess team.
Once you lose the edge.
Yeah.
It's.
I regret it.
Okay. I got one topic that.
By the way, this seems like a good time to interject that listener number 12 of the ITR podcast was a member on Des Moines Christian's first state Quiz Bowl team, which I think is right behind the chess group. So
yeah,
there's a lot of intellectual firepower between our guests and our listeners here, Chris.
I have a child that's a current Des Moines Christian Quiz Bowl participant,
but he's not the first.
No,
like listener
not.
number 12 is.
Yeah,
and that's my point. Trailblazers here.
Yeah. Okay.
Go big or go home.
That's right. Okay. Chris, you sent me this bit here yesterday, but there's another $43 million recreation center being proposed by.
No, $43 million was the price on Urbandale.
Oh. So, okay. Well, apparently Shive Hattery, the architects, pulled the same plan down off the shelf and are shopping it around because the city of Pella also wants to have a $43 million recreation center. Funny how that works.
Oh, well, we know
which is
going
bigger,
price of money.
Pella or Urbandale?
Urbandale by quite a bit.
Huh. Okay, go ahead.
Yeah. Now, to Pella's credit, they actually went and found some private dollars to put into the proposal and didn't just go 100% on the backs of the property taxpayer. But it is interesting that it's $43 million once again and bonding off of their local option sales tax. And apparently people are mad. They don't want this big recreation complex in their city. So we're going to be paying attention to that, following that, and what happens with that proposal. But it doesn't necessarily involve a ballot question, but it'll be up to the folks in that community of what they want to do with that. I can say, and this is a objective, quantifiable fact, that the Pella proposal is every bit as ugly as the one that was proposed for Urbandale. They're both just ugly concrete bunkers with obnoxious angles and
weird
glass in the wrong spots.
Because even like the Casey's in Pella have a unique, distinct kind of Pella-ish look.
Right. For a city focused on its sort of architectural charm.
Yeah, wonderful place.
Right. It is going to be an obnoxious modernist concrete bunker.
Kind of the equivalent when they just dropped the new version of Soldier Field in Chicago.
Yeah, like
spaceship
that.
landing there.
The Walmart will be significantly more attractive to look at than their new rec center. Unquestionably.
Well, Walmart probably didn't cost $43 million.
Yeah. Have you ever heard my rant on architectural styles?
No, but I'm down for it.
Okay, good.
Can we work into the podcast? So I live in Altoona, and we have a sculpture at one of the roundabouts that they've built there that is like all the leftover Armco barrier from some road construction project, and it got all twisted up, and they put a purple light on it. And I don't know what exactly we spent on that, but it was six-figure roughly investment in public art that I'll just say this in all seriousness. I mean, the banter's fun. I don't want to stop the fun here, but engagement at the local level is super important. And I think people are increasingly aware of the fact that you need to be engaged with what your local government is doing. You get your property tax bill in the mail. About 53% of that, give or take, is going to your local school district. The rest is going to city and county and then some smaller taxing bodies. It's a significant amount of money that you're laying out every year in property taxes. And guess what? If you rent property, you're still paying property taxes. It's just built into your rent. You don't see it directly. And be engaged, be involved. Vote in these local elections, maybe run for office yourself. And you can ask questions like, why do we need a twisted pile of metal for public art? Or why do we need a rec center here? Or and if you feel like it is a need, then make the case and have people engaged and they can vote on it. And if you can make that case and the community decides on it, fine. But engagement at the local level is something that really is important. Those local elections need more turnout. They're normally, 10, 15% turnout at best. And we need to be part of the narrative of changing that and getting Iowans to show up and vote in their local races.
Well, and I think I was heartened a little bit through this that I think we may be starting to move the needle on that is that, well, with the Urbandale bond referendum, we did have...
What was the numbers on that defeat again?
83% of the folks voted no on that.
Wow.
And on huge turnout. We had more people vote in that ballot question on the bond referendum than had voted in the last city council race.
So I want your audience to know, your large audience to know, I have a bachelor's degree in political science. And I can tell you 83% no is bad if you're the proponent of the rec center.
That's why we bring you in right there.
Yeah.
That expert analysis that our folks need. But at least I saw an article on KCCI's website about the Pella project, and folks at that city council hearing had referenced the Urbandale outcome. And so these things start to reverberate and you see people showing up. And we saw people show up in Warren County for their maximum levy hearing. And now it's encouraging. We want these people to show up and take control of their cities and their spending and ask those hard questions. And it's happening. And now we need a lot more of it, and we're going to continue talking about it. But I think you're exactly right, Alan. And hopefully we're early days of that really changing in Iowa where people do show up and engage at that level and ask those questions. Okay, so we teased this out in the last episode, Alan, that I wanted to get your take on a Iowa Supreme Court decision that was handed down on Friday, which was the title was LS Power Mid-Continent LLC versus the state of Iowa, I guess would be the short caption on that. You're familiar with it and you kind of know what the case is about. So there's the merits of this, which is about utility regulation. But then there's some of what it was decided on mostly, which is kind of the operation of the legislature and its implications for that. So I want to bring you in. What can you say about kind of the substance of the case itself?
Sure. So we'll set this up for the audience. So utilities are a highly regulated space, and there's some good economic policy reasons why that has to be, although that doesn't mean regulation solves all of the problems we have with utilities or all the issues out there. But there's a high level of regulation involved in how you get electricity and natural gas to your house. In this situation, it deals with how do you deal with building more infrastructure for the transmission of electricity from power plants to the grid so they can eventually get to consumers. These are huge, expensive projects. They can be controversial because sometimes they involve eminent domain. They're big projects. They're expensive projects. Utility ratepayers ultimately bear the cost of the electrical transmission infrastructure. And so those ratepayers benefit when there's more competition for providing those services to you, because you want the lights to turn on in your house. You don't care where that electricity came from. And ideally there's competition for the generation and transmission of that electricity so that it's available to you when you flick a switch. So what happened is, in the regulatory process to build more power lines, the legislature in Iowa passed a statute that said essentially the incumbent participants in that market, the firms that are already out there providing electrical transmission capacity, have the right of first refusal to go in and take over a proposed project that gets regulatory approval. And the concern with that is it may reduce competition. And so the question is that good policy? But what the court was looking at here is, how did the legislature come to passing a law that gave that benefit to the participants in the marketplace? And normally you wouldn't do that. If somebody wanted to build a grocery store in your town, you wouldn't say, okay, we think the grocery store is great, but we're going to let Hy-Vee and Fairway bid first to see if they want to open the grocery store.
You would if it's a medical facility, though.
That's a whole other issue that we can get into.
Well, we have.
Well, I think it'd be a little bit more fairer to say that the state doesn't get in the middle of that process, except for the situations in which it does.
The default rule is
yes.
You let free market forces work.
Right.
You let firms come and go to provide goods and services that consumers want, and you will get the most efficient allocation of resources if the government gets out of the way. There are things the government has to do. The government has to provide rules for property rights and prevent fraud and to adjudicate disputes. But government is very poorly suited to decide where a grocery store should be, or where a power plant should be built, or who should open a coffee shop, or who should open a medical clinic, those kinds of things.
Right. So, yes. So this piece of policy, in disclosure, I was still in the legislature when this passed. It was my last year up there. Gets put in at the end of the year in our standings bill. Now, standings is often one of the last bills considered. It is standing appropriations. It's the other things. The biggest piece of it is usually the actual dollars for school funding. But it's those things that the ongoing obligations of government. And it can often be what is colloquially referred to as a Christmas tree. And, you put some other pieces on of policy that you just need to still get done. So
and that's how the system works, for right or wrong. That is how it functions.
Yes. Look, it is. There are amendments to bills all the time. And so the standings bill had this put on it, this right of first refusal, passes and was challenged in court. So this is the ultimate adjudication. Well, not the ultimate, but at least for this round, it was remanded back to district court. So, but what troubled me, or at least, yes, it troubled me, was two things that were in this decision. I want to get your take on this, Alan, is the court quoted at length the floor debate on the standings bill in the state Senate, which had occurred in the middle of the night. Now, by way of context, the 2020 legislative shutdown was done after about a 2 to 3 month shutdown because of COVID. Right. So we got up and left town, just dropped everything and walked out of
3 years ago today,
right,
roughly.
Walked out of the building.
Yeah.
Passed a resolution that says, we're keep some amount of the lights on, but we're leaving. And then we came back in June, I think, and raced to get everything done because nobody wanted to be in the building together, but yet we had to do it to kind of do some of the basic. We had to pass the state budget. So we had to bring everyone back together, do it, and get back out. I think it was about a week that the legislature was back in town. So anyway, that's the context, which I think is important, that why this was being done in the middle of the night. Debates go late, but there was a lot of work that had to get done in a short amount of time. So, but the court quotes the floor debate and what they characterize as the misunderstanding of the policy by the senator floor manager of the bill. And secondly, it relies on some previous rulings about a bill or a piece of policy's path through the legislature. And they say that because that bill did not make it out of committee, that was somehow indicative that this was log rolling because it died earlier, it got added later. I'm troubled by the court making value determinations on a piece of, on a law, on how it moved through a separate branch of government. It seems to me that a law under consideration by our court, that law needs to be decided by what's on the page. You know, the four corners of the document, as you will. They don't need to figure out why a certain committee ran or didn't run a bill, because believe it or not, there are other reasons that bills don't go through committee than they don't have support at that given time. They ebb and they flow. And yes, there are floor managers that don't always fully understand the legislation that they are running. That happens.
I mean, if I had a nickel for every time
So I want to hear, there's no question there, which makes me a bad podcast interviewer, but I want your take on some of that.
Sure. So maybe I'm going to start kind of at the end there when you're talking about the legislative process and the floor manager. And again, bachelor's degree in political science here. I know you were actually in the legislature, so we'll see if our thoughts jive here.
And I still, as much as I get frustrated by what they do or don't do sometimes, and I'll be their first cheerleader when they do the cool stuff, I still have an affinity for the institution and how it works. And maybe I'm one of the elder statesmen that goes up there occasionally, but that is a separate branch of government, and it needs to look out for its own interests. And this is one of those times that I think that needs to be taken care of.
So first of all, the separation of powers, each branch of government protecting its own turf is hugely important. And I agree with you on that. The legislature has its prerogatives. It is 150 people who are the living, breathing embodiment of 3+ million Iowans who are there to decide, what the rules are going to be. So there's provisions in the Constitution that say that a bill can only be on a single subject or any matters properly connected to that subject, and that those subjects have to be expressed in the title. And it was those clauses of the Constitution or those provisions of the Constitution, I should say, it's all in one clause, that the Supreme Court was looking at and saying that this right of first refusal language was unconstitutional. So it inevitably gets a little bit into the legislative process to do that. The court does have a role to decide the constitutionality of statutes. But you raise an important point about the legislative process. A lot of people think that the real work that the legislature does is the visible part, is floor debate when the whole body is assembled and voting on a bill. And I will tell your listeners, and I'm confident you're going to agree with me, Chris, that the work of the legislature really does not happen with 100 members of the House on the floor for debate of a bill. The real work of the legislature happens in committee. It happens in subcommittee. It happens in party caucus. It happens in staff work and deciding what bills should be moving through the process. And in a legislative body, majority rules.
That's unquestionably true.
Right? And people, I don't know how much your audience has seen Mr. Smith Goes to Washington. People do not sit there on the floor and hear debate and are persuaded to change their votes. Or
my first day ever at the Capitol, I was expecting Mr. Smith Goes to Washington, and I did not get it. No disrespect to you, because you were on the floor at that point, but that was not what I got.
No,
and that's not. That's not how it works in Washington D.C. either. That's just not how it works.
I can think of a small number of bills where an individual legislator may have changed their vote because of some floor debate. I can't think of one. I can think of one where the outcome of the bill was changed because of the floor debate. And even then, I think there's an argument that it wasn't necessarily a floor debate. But we'll get to that another day when we're back telling old stories. The floor debate doesn't matter.
It is performance art. For political reasons. The floor manager is supposed to run the bill. The other party, if it wants, will ask gotcha questions and try and frame the messaging of it. And so for a court, I agree with you, to weigh the constitutionality of a bill based on what the floor manager says or doesn't say. Because the flip side of this is, if the floor manager is super eloquent and the member from the other party doesn't ask very good questions, does that make this bill constitutional?
Right.
I don't think so. Now,
so I want to ask a question on this, because I have asked this of others that I've talked to about this bill. If floor debate is relevant in any way, if it's all performance art and doesn't matter and doesn't impact the bill, what the language of the bill is, its final passage, if it doesn't really matter, right? And yet it is being used to determine the constitutionality of the law, why would any legislator offer any comments on any bill on the floor of the House or Senate? Why would a floor manager not get up and say, "Thank you, Mr. Speaker. This is House File X. This is House File 123, deals with this. And due to the Supreme Court's decision in LS Power Mid-Continent versus the state of Iowa, declined to give any other comments on this bill. Sit down and move the bill." Why would that not be the outcome of this?
right. I mean, the legislature, when it speaks, the legislative body speaks through bills and resolutions, not through comments by other legislators.
The text of the bills.
Right. Right. It's like back in the old day when I was a prosecutor, judges sometimes would talk themselves into a reversal at sentencing because they get really verbose and
right.
And I'm imposing this sentence because I don't like the way you're staring at me right now, and I think you're a criminal through and through. And that joker is coming back.
I'm a former defense attorney. I've seen it. So.
Right. And so and the podcast is not long enough right now for me to tell a great war story about a sentencing getting reversed twice because the district judge lost his or her temper. And what you get eventually is district judges, as soon as they get reversed on that, here's what they say: I'm imposing this sentence in order to advance the goals of individual and general deterrence and to maximize your opportunities for rehabilitation.
Yes, that's right.
And that statement of reasons is appeal proof, right? So it's the same idea.
Right.
Less is more then in that circumstance. Now, the court, I think, could have reached the same result by simply saying, look, you put substantive policy things in a bill that has appropriations and code correction language in it. We're going to let you lump in all the appropriations stuff. That's on a single subject, paying the state's bills, and code correction stuff doesn't affect anybody's substantive rights, fixing typos in bills
right.
and things like that. And I will say this, I think lawyers now and for all and this is going to sound self-interested, and it is, if for the institutions, organizations that are participants in the legislative process, after last Friday, if there's anything substantive in a bill, along with appropriations or code correction language, there's going to be a race to the courthouse. Okay.
Yes.
And so since last Friday, the answer is you better be lawyered up, because if you lost a policy fight, you have a very limited window to run to court until that's codified and file a lawsuit and challenge citing LS Power Systems
right.
as the case. And whereas if you've achieved some policy outcome, you also need to be lawyered up, because this frankly is going to be a case that is cited a lot.
Yeah.
And we'll see how it plays out.
And I'm not, there's another part of this, and I think you touched on this, Alan, that, the title of the bill and the Constitution requires that the title be clear. Okay. I mean, I can argue that both ways. I understand the court's logic on that. They provide no real standard for how specific the title needs to be, other than that this one wasn't good enough, but you don't have to recite the entire, case either. It's just, it all seems so haphazard. But yeah, it's not a good outcome for the court to place value judgments on how the legislature doesn't work. It's not good for every single piece of high-profile policy to be relitigated through the court system after the legislature has disposed of the issue. There's just a lot of not good outcomes here.
That's, yes, from the legislative process part of it. Now, in defense of the court's decision, Justice Waterman, who's the author of it, has a very nice paragraph or two in there decrying what he calls, this is a quote, crony capitalism.
I read it
in the bill.
My eyes were drawn right to it.
And competition is good. And so, Chris brought up certificate of need earlier.
We like to cross promote our issues on this podcast, Alan.
So certificate of need is a process where if you want to compete with an existing hospital or other medical institution, you have to get a competitor's permission, essentially. You have to go through this administrative process and fight your way to be able to compete. We have at Kirkwood Institute a lawsuit going right now challenging Iowa's certificate of need law. And I'm not violating any attorney-client confidences when I tell you that within 30 seconds of reading the crony capitalism line, there was a copy of that decision forwarded to a lot of people.
Yeah.
Right? And coming to a court pleading near you very soon.
Right.
Right. And I like that. I agree with that.
And I don't disagree with the sentiment that Justice Waterman gives there. That's on the substance of the issue itself. My reservations are process oriented. But yeah, I think there's, depending on where you fall out on the issue, there's good stuff here that is going to impact other decisions down the road. I think this is a consequential decision by the court. No doubt about it.
I think we're going to need to see, is this ticket good for one ride only? Or, will the court embrace the litigation that will come citing this and building legal theories around this decision?
I'm not a gifted enough court watcher or a constitutional scholar to really have an informed opinion, but I think once this comes back around to them, I suspect that at least on the legislative process things, that maybe some cooler heads will prevail and we'll keep things limited to some pretty narrow ideas on single subject and log rolling, because the legislature needs to be able to function, needs to be able to do its business.
Well, and one of the things that's a feature of this that we haven't mentioned yet is, so the Supreme Court has 7 justices on it. There were 3 of them who were recused from this decision. 2 of them were in private law practice when this case was bubbling its way up through the system, and their firms were involved in the litigation still as a party and as an amicus. And then Justice May, who was put on the court last summer by Governor Reynolds, he was on the Court of Appeals, and the Court of Appeals had decided, and then it went up on further review, so he can't participate. So only 4 of the 7 justices participated in this decision. Now, that is a majority. It's a quorum. The court can act. But in a future case where presumably the other 3 are not recused, they can participate, and those cases will be different, and it may, those cases might end up getting decided by different factions. These issues are not just cleanly all just on one side or the other.
And the question I have, as this case is now remanded and works its way back through the system, do those recusals need to endure with that? Or if it comes back up a second time now that those justices are on the court, or is it still going to be just the 4? Do you see my question?
So Justice May should be able to participate
because it'd be a different,
it would be a different appeal case. Now, justices are not required to state the reasons for their recusal. So Justices McDermott and Oxley didn't state the reason.
Presumably.
McDermott's old firm was representing LS Power Systems. So, that's pretty obvious why he recused himself. And he was a top litigator at that firm. I'm sure he had a hand in it. So if he had personal involvement in it before, he can never be involved in the case later under the rules. If he recused simply out of the appearance of it because it was going through the office while he was there, but he had no involvement, he could participate later. But it's really up to the justices to decide that themselves.
Good. It's interesting. Did you enjoy this conversation, Chris?
I did. I was going to say for the listener, but I really mean for myself, Chris. I understand what your overarching concern is with this, and it's not so much the ruling of the case itself, right?
Right.
It's what it potentially is. It's the can of worms that it opens, right? What is a potential fix or resolution to that issue? How could that come about? How could your fears be calmed or addressed?
I'm not entirely sure of that. Yeah. I mean, I gave my thought. If I was still leader, I'd be giving very serious thought to telling my members to offer absolutely nothing on the floor, especially on a bill that is very likely to end up in the court system. And that, as much as it is performative, Alan, I think it is a part of the process that has some validity that should be preserved. If I was a legislative Democrat, even though I probably like the decision, I don't know whether I guess I really do or not. I mean, one of the minority's powers they still have is debate and getting up and trying to grill a member and trying to trip them up. It may not matter, but it's one of the tools that they have left. And now you might be taking one of those tools away. So I don't know. I might be overthinking that too. I don't really know. That's why I hope that when this case presumably makes its way back to the court again, or another case, is that they can better define whatever this is that they've set out on in a way that can provide the legislature with some assurance that they don't need to remake their process to fit inside of these new dictates from the court.
I think going forward, ultimately the fix from the sense of if you wanted to never have to worry about a statute being found unconstitutional, one fix would be to amend the Constitution to repeal the clauses that said it was. That's probably not realistic. The other fix is for legislative leadership to decide we're not going to put substantive bills in amend the standings bill to include substantive stuff.
And I think that might be a good outcome. I mean, in my tenure, we worked pretty hard to keep policy out of appropriations bills. And that, generally speaking, was a goal. Now, some of that was self-serving because it made it easier to move the appropriations bills. But you want to keep that clean as much as you can.
Right.
So that might be a good thing. So I don't take any position on that, but on
the scope of what does the minority party have left, I think you make a good point. And if something completely quashed debate, that would be bad for the minority party. It's interesting, and let me tie this into another single subject case that came down last year, and that was the abortion case, Planned Parenthood of the Heartland versus Reynolds, PPH v. Reynolds 4 is what we call it. That one dealt with a 24-hour waiting period. I wrote an amicus brief in that case on the single subject clause, and the district court there found the 24-hour waiting period bill to violate single subject, which was frankly a pretty out there decision. And so I wrote an amicus brief on that. And the history of the single subject clause and how the legislature does its work convinces me there's really no justiciable principle that the legislature will combine subjects as it sees fit. And the whole history of codification, we can get super nerdy on how the Code of Iowa came to be. The legislature has enacted whole sections of the code in big blocks from time to time. And you can make the argument under single subject clause that all of that's unconstitutional. You can make an argument that everything that the legislature has codified since 1927 is unconstitutional. Now, I don't think there's 4 votes, let alone 1 vote on the Supreme Court to uphold that theory. But, at some point, this really diminishes the power of the legislature. Well, interestingly, in that litigation, legislative Democrats joined an amicus brief telling the Iowa Supreme Court that this bill violated the single subject clause, that 24-hour waiting period bill, which I just found fascinating. Okay, show me that you think you'll never be in the majority without showing me, right?
Yeah.
You have legislative Democrats asking for a rule that would cripple the ability of the legislature to craft bills as it sees fit. Well, these Democrats who signed this brief are basically saying, we think we're never going to get the majority back. So the only way we're going to chip away at things that Republicans are doing is to get the court to strike them down. Right? Talk about not protecting the institution. Right? I think they're probably right, given the way
Well,
Given,
yeah,
you know, they're
yeah.
probably not going to get the majority back.
Not for the foreseeable future, but everything cycles.
Right.
It's just a matter of how long you have to wait.
Right.
So, yeah, and it probably every single legislator. Well, I shouldn't say that. Most of them probably are long gone before they win a chamber back.
I will say this for legislative Democrats. It can get worse. In 1927, the Iowa Senate was 49 Republicans and 1 Democrat. Okay, so it can get worse before it gets better.
Yeah, we could go back to 1 senator for every 2 counties.
I want to do, I have a goal, maybe when I retire, do a little history project, because I want to know more about that one guy who was minority leader and ranking member on all committees. 49-1. Can you imagine?
It'd be some short caucus meetings.
Yeah.
All right.
Yeah.
Alan, this is really good. Really good stuff. And, we've talked in the past as your 3rd visit that we want to have you out here to talk about some of these decisions and cases because I think you provide a lot of insight. And so we really appreciate you coming by.
Well, I'm glad to do it.
Yeah.
We're coming into the really heavy part of the court's term. They will wrap up all their cases by June 30th in this term. And they are getting their decisions out a lot faster. Mm-hmm. Justice Apple retired from the court, and he was known to write a lot. It may take a little bit longer to get decisions out, but we'll have a lot in the pipeline here, and I'd be glad to come back and
That'd be
discuss
good.
it.
Look forward to that. All right, Chris, thanks for the legal analysis along the way.
Glad I could offer so much, you guys.
He's like, there's a half hour of my life and I'm never getting back, right? All right. Well, gentlemen, thanks a lot. Thank you, listeners. Thanks for being part of the ITR Live podcast. Don't forget to like and subscribe and share with your friends. Don't forget to check out kirkwoodinstitute.org.
kirkwoodinstitute.org.
On the web and on Twitter. Alan's got a lot of really cool stuff that he's working on there, and it's an important part of the conservative movement in Iowa. And so we appreciate you being here and being part of it. And with that, we will see you next time on ITR Live.